Okay, Chairman, we're live.
Thank you, and welcome to a virtual meeting of the Licensing Committee at the London Borough of Hillingdon. This virtual meeting is also being broadcast simultaneously on the Council's YouTube channel, Hillingdon London. The purpose of the committee is for councillors to review the Council's licensing, gambling, street trading and similar regulatory functions and keep abreast of any relevant developments. My name is Councillor Simon Arnold and I am the chairman of this meeting. Some online housekeeping before we start. Some important things for everyone to remember. Please ensure any mobile phones around you are on silent. Please keep your microphones muted when not speaking and then unmute to speak. As chairman, I will call on those to speak during the meeting. If you wish to speak, please indicate by using the raise hand button on your screen. In terms of technical meeting control, if any councillor leaves the meeting partway through for a period of time, e.g. lost connection, I will continue the meeting unless we are not quorate, which in this instance is 3 councillors. Before we move on to the agenda, I'd like to do a roll call of the councillors and other present to confirm attendance. Please indicate you are present when I say your name. Councillor Alan Chapman, Vice Chairman.
Good morning, Chairman. Yes, I'm present.
Morning. Councillor Lynn Allen, the Opposition Lead.
Good morning, Chair. Present.
Good morning, Councillor Allen. Councillor Nick Dennis, I understand we have apologies from. Councillor Janet Gardner.
Good morning, present.
Good morning, Councillor. Councillor Ray Graham.
Good morning, Chairman. Present.
Councillor John Hensley.
Good morning, Chairman, and I'm present.
Good morning. Councillor Carol Melvin.
Good morning, Chairman. I'm present.
Good morning. Councillor John Oswell.
We've had his apologies, Chairman.
Oh, yes, thank you. And Councillor Colleen Sullivan.
Good morning, Chair. I'm present.
Thank you, councillors. Can I also introduce the officers attending today to advise the committee? Please indicate you are present when I say your name. Glenn Egan, Office Manager, Partner, Legal Service. Please.
Good morning, Chairman. I'm present.
Good morning, Glenn. Stephanie Waterford, Senior Manager, Licensing and Regulatory Services.
Good morning, Chairman. Present.
Good morning, Stephanie. Daniel Ferrier, Licensing Team Manager.
Good morning, Chairman. Present.
Good morning. And Mark Braddock, Senior Democratic Service Manager.
Morning, Chairman. Present.
Good morning, Mark. We now move on to the agenda. Apologies for absence, please.
Thank you, Chairman. We have apologies from Councillor Dennis and Councillor Oswell.
Thank you. Declarations of interest in the matter before this meeting. If I don't hear anyone, I will assume that there aren't any. Thank you. To receive and agree the minutes of the meeting held on the 14th of October 2020. Everyone should have looked at those minutes. Unless anybody has an issue, I will deem those as approved. Thank you. To receive and agree the minutes held on the 14th of January 2021. Again, unless anyone has any objections, I will deem those minutes approved. Thank you. Where are we? I can confirm that the meeting will review 2 public reports this morning and 2 private matters as set out in the agenda. We now move on to the public agenda, starting with item 6. Bear with me one moment while I just put it on.
And Chairman, that will be Stephanie, I think, introducing this item.
Right, yes. Stephanie, you're going to talk us through the review of licensing subcommittee hearing protocols and the application process. Please, Stephanie.
Thank you, Chairman, and good morning, members. So members may recall from the October meeting that we had a brief discussion, sort of workshop really, on certain procedural matters that members found would benefit the quality of the information contained in the reports that you receive and also the procedure at the licensing subcommittee hearings. what prompted that workshop to take place was that we'd reviewed the statement of licensing policy, and that was agreed and adopted and came into force in January 2021. So it seemed timely to review our hearing protocols and also our kind of back office licensing report procedures. So following on from the discussion, there were a number of matters that members proposed, and this was mainly to do with certain things, the quality of evidence and the submissions and the arrangements leading up to a hearing in order to ensure that you've got all the decision-making information that you require. So what we've done, we've only proposed some very, very minor amendments to the actual protocols because overall they comply with the hearing regulations. There hasn't been any major changes in terms of the hearing regulations since 2005. They've served us well. So the protocols only need a couple of little tweaks, and I've proposed those on page 10. And you'll see the header there, change to hearing protocols, and we're just proposing to insert those two sections into the protocols, which cover this sort of licensing policy advisor role, which would be the kind of expert policy advisor to advise on complex cases, and also the site visit for certain cases where members felt that they needed to have a greater feel for the area or for the impact of a license application. So we're proposing those two sections to be inserted into the protocols. I think the majority of our changes are actually in the report procedure itself. This is our sort of back office procedure and our officer protocol for doing those. And the next section on page 10 actually just proposes gives a summary of the changes that we're going to make. So a requirement to include company's house information in the subcommittee report, which I know has come up sort of on and off over time. So where the applicant is a company, for example, we will include that company's house information, so members will be able to see who the directors are, who the controlling shareholders are, that sort of thing. A requirement for licensing officers to include information from police where crime and disorder incidents are mentioned by residents. So this is something that often creates a disparity where we have a number of residents who may raise crime and disorder concerns and make claims that they have called police and that they've reported matters to the police, and we now have a requirement for licensing officers to kind of fully exhaust those inquiries with the police themselves. And even if it's a return that's from the police officer that says, there's nothing on our system or there's no information to give, that at least provides you with the police viewpoint in order to assess that in line with the residents' views. We've also put firmer guidance in the resident representation form around quality of photo and video evidence. I know this is something that's caused some frustration for members, where we'll have submissions put forward by a resident or other interested party, and the quality of the photo and the point they're trying to make with that photo or video evidence isn't always clear. So we've kind of bolstered the officer's role in getting to the bottom of the point that the resident is trying to make with that photo and video evidence, and to ensure that it's clear, it's legible, it's date time stamped, and all of that sort of thing. So that's a summary of the changes that we're proposing, and we have provided you with kind of the whole back office procedure, just so you can see. And in that, we've obviously got the representation form that residents can use, which is something you're probably all familiar with, and you can see that the notes on the back of that form do mention in a bit more detail about the evidence. We've also got the petition template, which really goes over the same thing, or it's come out a little bit skewed on the printout here. And we've also got templates for internal licensing, responsible authority representations, and then our report template. And you'll see that the company's house information has gone into the template as a default appendix where there is company information. So if members have any questions, I'd be happy to take questions at this point.
Thank you very much, Stephanie. I think that was very clear, but there are a couple of members that have questions. We will start off with Councillor Allen.
Thank you. On page 33, on 2.3, it says licensing officers will ensure that applications are posted on the website displaying the correct consultation rate. I'd like to see it on public notice boards as well, because I've said here earlier, not all residents have access to internet, and I don't think they should rely on carrier pigeons or local councillors to alert them to something that should be public information. We have those boards across the borough, we have them outside the civic. For what purpose? Public information. So I would say we want that back where they used to be, as well as in the internet. I'll come on to something else later. I don't know where I'm going to bring it in, or can I bring it in now? We talked about where officers do their work looking at different sites. We found that time and time again we've sat on committees where we've been told by officers that this is the hours these people meet, and yet take a look on YouTube or any of the other sites and we can see what's really going on. And that's how we came across some of the things. So I don't know where you're going to put that in, Stephanie, but I do think that officers should be looking. If you're talking one stage about alerting people to the internet, the very thing you should be doing is using the internet. Thank you.
Thank you, Councillor Allen. I think there were two parts to your question there. The first was, are we able to publicise on the relevant boards? And the second being that you believe the officers should be doing more research online against what the application says, and whether they're saying the same thing on their own websites and other places such as that. Yes. Stephanie, did you want to come back on any of those?
Thank you, Chairman, and thank you, Councillor Allen. I'll take the first point first of all, with regard to notice boards. We never have, as you know, advertised on notice boards in the same way that planning applications and other kind of highway applications and other statutory notices aren't put on those notice boards. And I think for the very fact that the volume of it, the volume of the applications coming in would make that quite difficult to work, and the rapid sort of changeover. I mean, we get hundreds of applications a week through the team, and to actually administer that, I don't believe that would be a productive use of officer time when there are other ways to obtain information on licence applications. For example, people can sign up through the website for email alerts to receive notification of licence applications. Did you want to come back, Councillor Allen?
Yes, I do. You say you don't use notice boards, you say you have hundreds coming in. You only have to look at how many hearings there are to say that the hearings are actually not that many. Otherwise, the three councillors on my side wouldn't be scrabbling around trying to get a place on one of these committees, because they are so few and far between. So I don't accept that argument. I think there are notice boards. The councils put them up on all estates. They are outside the civic centre steps. So I do think, and you used to notify associations where they said, could we please be notified of anything that's happening in our area, planning? Well, I think licensing should be doing the same. If we want all residents to participate in keeping our areas safe, then we should be doing more about it. And the use of those notice boards, I think, is a priority. Yeah, because while your officers, let me finish, Stephanie, while your officers are out there looking and setting up, yes, we are going to have a meeting on this, that notice could be there. Otherwise, are we going to go back to Barney Rubble? Because if you've only got an internet, that's the only way you're going to be included. Let's put residents first, please.
You're on mute, Stephanie.
Thank you. It's certainly something we could look at. What I would say is that any departure from our policy on notifying residents would mean a change in policy. So we have a level of what we propose to do for residents in terms of notifying them, and at the moment that is limited to the statutory minimum. If we were going to go over and above that, we would require a change in policy, and if that is something that members wanted to take forward, that is obviously within your gift to make that proposal.
Did you come back on anything, Councillor Allen?
The last thing I would say, this council's strapline is putting residents first. If a resident does not know what's going on in their area because they do not have access to internet, that means you are not, this council is not putting them first. So yes, it might mean a change of policy, Stephanie. I've got no problem with that because we are here to put residents first. I don't want to have to go around with a banner saying to the residents, I've got this list. That's not what a councillor's role is. That is the council's duty. We are there to pick up on residents' concerns and take their case forward for them. We are not there as a public information board for the council. So I'm asking that does get looked at and it does be a policy change.
I would defer to my colleagues in Democratic and Legal for advice on how we go about changing the policy or considering Councillor Allen's request to change policy.
Glenn, I saw you put your hand up. Did you want to come back on that point?
Glenn, you're on mute.
Yes, thank you, Chairman. Just one thing that occurred to me during the debate then, I may stand corrected on this, but I think whenever an application is made to the council, a public notice has to be placed on the premises concerned. So passers-by and users of that premises can automatically see what there is and make representations. Obviously, if members wish to go through a process of changing the procedure, I can give advice on that. We can bring a paper to a future meeting. But members may find that's that the notice on site is a more effective means of alerting someone to what's going on those premises than, say, a notice board on an estate or a park. But obviously, it's a matter for members to form a judgment there. The other thing I would say is, again, the council's role here is to publicise in accordance with statute and to be neutral. Once the council starts departing from the statutory guidelines and putting information and perhaps on a wider domain, and the council is then liable to accusations: are you favouring one applicant or you're not favouring one applicant? So it's a careful balancing act there. And also, as Stephanie says there are resource implications for this. If the council is going to send officers out to put notices up on notice boards, that may divert them from some other duties. But of course, that's a decision for members to take. Thank you, Chairman.
Thank you. Councillor Allen, there are several other councillors that wish to speak, but if you come back quickly, and then we can...
Yeah, very quickly. Firstly, the notice used to appear in all the local gazettes until the gazette went because Hillingdon people took all their trade. So therefore, we do not have it publicised in the gazette, which all residents used to get sight of. The second issue, and officers are well aware of this, those notices that go on the premises go in the premise window. If you've got a pub that local residents walk past but do not go onto the pub's curtilage, they will not see that sign. And I've raised this since I very first become a councillor, and I was told it would be looked into, and it never has. So they're 2 points that you should be aware of: the gazette and the citing of the paperwork.
Thank you, Councillor Allen. I think your point has been well made, but I am going to take some other questions. There are 3 other councillors I've indicated. I'll start off with Councillor Gardner, then Councillor Hensley, then Councillor Chapman. But for now, Councillor Gardner, please.
Yeah, my concern is the application procedures documentation, where it says requirement for the licensing officers to include information from police where crime or disorder is mentioned by residents. I think that somehow we...
Sorry, could you give us the page number?
So that residents, which is page 10, the last paragraph, on the second bullet point. I think that we need to encourage the residents to say that they've got to report items of concern to the police, because otherwise there's no crime reference number. There's more, but I think a lot of residents forget about that. I think that's something we could, even if you say that they can start 101. The other thing that worries me says firmer guidance in the residents' representation form around the quality of photo and video evidence. That's something else we need to impress on them. I don't know how we can do it. As I say, I agree with Councillor Arnold that not everybody has got access to the internet. I mean, maybe we should have it in plain English on our website. But I also think that I'm just saying this, that maybe we ought to advertise it in Hillingdon People, and also when we get the when the new licensing applications come in, if they're relevant to our ward, we get them. It might be good just to have a few bullet points regarding that, so that if anybody queries with us, we can then get back in contact with them and say, yeah, if a resident contacts us, you know, you've got to do this and you've got to do that.
Thank you, Councillor Gardner. Stephanie, did you want to come back on any of that?
Thank you, Councillor Gardner. So the point of the procedure being updated is that it's a reminder to officers when they're the case officer dealing with the application to actually extract that information and to make sure that it's of a quality that members would expect in the report. And yes, you're right. I think we could put an awful lot more guidance on the website, you know, in the plain English for residents, and it would also form part of the information that we could send out when we're speaking to residents as well, and they're making inquiries about a licence application. If we kind of have a leaflet or something a bit more easy read, user friendly, just with those bullet points made very clear. We're happy to work on that with comms and get something out.
Thank you, Stephanie. Councillor Hensley.
Yes, good morning, Chairman. I refer to page 10, bullet point 2, is to do with site visit. Going back to my time in court, that you sometimes find when the evidence is being given, you need the time to reflect and get more evidence. And we use the term go part heard, and therefore the court appearance is adjourned and a date fixed. And all those people hearing that case are brought back. Now, it can be on the odd occasion when you hear representation at a licensing committee, and it's no different to that of planning, that information becomes available that is not normally available prior to the hearing. If that is the case, and it's deemed necessary on the exceptional case to have a site visit, is there the procedure that the hearing can be adjourned and reconvened with the same people hearing it, so as not to cause any duplication?
Thank you, Councillor Hensley. And Mark, that's probably a democratic service question. Can we resume a hearing if we wish to do a site visit once the evidence has been placed in front of us?
Absolutely, Chairman. This has happened a few times before, where the committee has requested additional information and it's adjourned, and then it's reconvened at a later date, and it is with, as Councillor Hensley said, with the same members of the committee. Yeah,
and it would have to be with the same members, because yes, otherwise it would be a whole new hearing effectively.
Start again from scratch. That's right. Yeah.
I think Councillor Hensley makes a good point there, which is that site visits, which I think are great to include in here if necessary, but sometimes you wouldn't know you wanted a site visit until after the hearing itself. So it's a little bit sort of back to front in a funny sort of way, but I think what Councillor Hensley and Mark has just confirmed is that there are ways around that if we want a site visit once we've had the first part of the hearing. Thank you, Councillor.
Well, Chairman, I just like to come back to you if that is the case, and many thanks for that information. Do we need to modify then the insert to reflect that, so it's embraced, and therefore an applicant can't appeal that they say you're not following your guidelines?
Stephanie?
Yeah, I'd be happy to amend that to say the visit carried out between the date of the agenda being published and the date of the hearing, or after the hearing has commenced.
Thank you. Councillor Chapman, you had indicated. And then
Thank you, Chairman. Yeah, I do have one point, but just before I raise that, I'll go back to Councillor Allen's point, which is what I wanted to talk about. Talking about site visits, they are I wouldn't say they're a standard item in planning applications, but as and when necessary, they're a standard tool that's available. And indeed, even during lockdown, we have, believe it or not, done virtual site visits, which are a bit of a strange thing, but we are in the 21st century after all now. What I wanted to mention was Councillor Allen's reference to notice boards. I'm not sure that notice boards per se are the solution, because obviously they are few and far between, and it might be the case that the nearest notice board is, let's say, a quarter of a mile away from the actual site. But again, going back to planning, it is standard to put notices in the vicinity of the applicant's house or building. So I certainly think there's mileage to put 3 or 4 up within, let's say, 100 yards, 150 yards, so that people who pass it and will be directly affected just in their normal routine are aware of it, as opposed to a notice board, which might be in a very prominent place, but it won't necessarily be anywhere near the relevant building that's the application for. Thank you, Chairman.
Thank you, Councillor Chapman. As Stephanie, you seem to indicate you want to come back on that. So
yeah, so I was just going to say that thank you, Councillor Chapman, for your suggestion. That would involve a departure from our statutory from the statutory part of the advertising procedure. So just to explain to members what happens when an application comes in, the applicant has a requirement, a legal duty to advertise that application from the next day that the application is submitted, and they have to do that by the pale blue poster that you're probably all familiar with, and it has to be visible from the boundary of the property. So you don't want to be in a situation where you have to cross the boundary, across the threshold into the building, into the site, to actually have a look at the poster. So it should be visible from the boundary. And part of our kind of application checks as officers is to actually go out to that site and ensure that those legal requirements have been complied with. And as soon as they've been complied with, that does satisfy the legal requirement for the applicant to advertise the application. And there's also the legal notice in the local paper, which has been referred to earlier. So as long as it's visible from the boundary of the premises, that should be adequate in order to kind of alert members, in the same way a planning notice would be visible from the boundary.
Thank you, Stephanie. Councillor Allen, did you want to come back in? You were indicating a few times.
Yeah, just a very quick one. On the fact of site visits, it should be made quite clear to all councillors that none should do a site visit on their own to any premise. And I've sat on this committee all these years, and a couple of times I've heard certain members saying, oh, I went along and did a site visit, and I went in, and I've had to point out to them, what are you doing? You're not supposed to. And they said, oh, it's okay, I was just going to have a look. Well, no, you cannot go and look, because any resident seeing you going to have a look would be able to say, were you there really to have a look, or were you there to have a chat to the landlord or the owner? And that could include bias. So can that somewhere please be put in? Because I wouldn't, up to this point, I've kept stum, but should it ever happen again, I'll be raising it at any committee that it could cause bias.
I think that's a very valid point, Councillor Allen, and I think it would, and Mark can probably correct me here, but I would think that's already part of members' protocol, that you can't go off and do individual site visits. Is that correct, Mark?
Yes, Chairman, there's elements within the Constitution and the member officer protocol around site visits, primarily though for planning. So perhaps we could look at adding something in more general, which would encompass licensing as well. And again, that would just be the subcommittee members. It wouldn't be ward councillors or anything like that.
No.
Be that on the subcommittee, yeah, as Councillor Allen said, yeah.
Thank you.
Thank you. I think we're about exhausted this now, so thank you very much everyone for your contribution. Thank you, Stephanie, for presenting the report. I think there's some really good things in there, some of which I think we should have had, like companies' house checks, probably quite a while ago. So it's good to update, and I think we should keep this debate going, and if we find other things that would assist us over the next 12 months, I'm sure officers would agree there's no reason we can't update this when we feel it's relevant to update it again. So Thank you for that. But we will now move on to agenda item 7, if my maths are correct. Yes.
Yes, Chairman, sorry to interrupt. Just to confirm, can the resolutions be proposed and seconded as amended as well, with that slight change to the site visits element? And then
I moved.
And I second that.
There you go. Moved and seconded. Moved by Councillor Allen, and was it seconded by Councillor Graham, I think? Right.
That's right. And I assume that's agreed by consensus, yes?
Does everyone agree? Everyone agrees.
Thank you, Chairman.
Thank you, Mark. We will now move on to agenda item 7. Sorry, my computer's gone haywire. Which is a presentation on COVID, I believe.
This is Glenn giving the legal update, and he'll also talk about the COVID regulations as well, Chairman.
Thank you for helping me there, Mark. Glenn, over to you.
Thank you, Chairman. I thought it'd be useful to update to advise committee of some of the actions that have been taken locally and also nationally in relation to enforcement of coronavirus restrictions. There aren't a great many cases that have been reported at the moment, and the reason is this. Breach of the coronavirus restrictions is a criminal offence, but it's normally punishable by a fixed penalty notice. But nonetheless, there can be a prosecution in an appropriate case. But breach of the coronavirus restrictions is not an imprisonable offence. It's only punishable by a fine. So at the moment, the Magistrates' Court, because of the restrictions there are in place, are only generally hearing cases where there is a possibility of someone going to prison. So it's the far more serious crime. So unfortunately, what I'm not able to update committee on is the stances that the criminal courts are adopting when fixed penalty notices have been served and not been paid, or there's been a prosecution. But what I have been able to do is find a number of cases across the country where there's been breach of coronavirus restrictions, where proprietors have not abided by the law and then have either had their licenses revoked or other enforcement action taken by the local authority. And just to mention a couple there that are in the report there, Chairman, you've got one in Manchester there where, because of breaches of the coronavirus restrictions, the City Council actually obtained a closure order that closed those premises for 3 months. So that was quite a severe sanction there. The restaurant in Notting Hill, so many coronavirus breaches always come to light because they're put on social media. That was one where a celebrity's birthday party took place. The restaurant took a spur of the moment decision to have the party inside the restaurant rather than a house. They were then closed down for 6 weeks as a result of that. Similarly, the restaurant in Woodford there, where there was a revocation of the license there for quite flagrant breaches of the restrictions there, including a party that was then broadcast on YouTube. And I think the most interesting case, Chairman, is the one involving the Office Public House in the Ealing part of Northolt, where there were very severe breaches of the coronavirus restrictions, and enforcement action was taken by the London Borough of Ealing. But when the pub appealed to the Uxbridge Magistrates' Court, the court took the view that the action taken by Ealing was insufficient and that they hadn't protected the residents enough from the risk of noise nuisance, which had taken place in the premises for some time. So on the appeal there, the district judge imposed greater restrictions on the public house than were otherwise imposed by Ealing. And I think that's a very interesting legal point there, because normally when people appeal to the Magistrates' Court, they think they're going to get a more lenient outcome. And actually, because it's a hearing afresh, the court can make any decision that the council could have taken, and can also take account of developments that have arisen since the subcommittee's decision. So on that case there, the district judge imposed further restrictions, and so when the licensing restrictions are removed on pubs, they will have to close, I think it's one hour before the designated closing time, and the late night opening is completely stopped there. So I think there's some interesting cases there, Chairman. Maybe at the next committee, when we've had some opportunity to take some of Hillingdon's cases through, we'll be able to update you some more on how those are going, and also if there's any developments nationally on when prosecutions actually start happening for breaches of these regulations. But I think what you can see there were ample tools available to the council. If the coronavirus legislation is breached by licensed premises, the council can revoke the licenses, and also the courts can revoke the licenses. So I'm happy to take any questions, Chairman.
Thank you very much there, Glenn. And I think that last case is incredibly interesting, where I don't think, is that quite common, that at an appeal the court would demand stricter rather than...
No, Chair, it is unusual. And normally what the court will do is say something like, well, I think the council has been very lenient in this case. It's not for me to substitute my view for what the council has decided. But in this case, I think because of the importance of what was the importance of what was going on, and I think the conduct of the licensee there, having a barricade so the police couldn't get in, and the noise nuisance that's gone on for such a long time, I think there the court took a lot of account of what residents were saying and basically had no confidence that the premises would operate in a responsible manner without further restriction. So that is a risk people take, yes, and it's quite a useful reminder there. That's the first one I've come across in some years.
Very interesting, thank you. Councillor Allen.
Just give you notice, I would like to raise something of this nature in part 2, please.
Thank you. Has anybody else got any questions? No? In which case, thank you for your presentation, Glenn. That concludes the public part of the meeting. Could I ask all councillors to remain on mute, and thank you for those watching on YouTube. Mark, if you'd like to close.
Thank you, Chairman. Yes, councillors, if you could just stay on mute and I'll confirm when the stream has been cut. Thank you.